Hello everyone, welcome back. Today we are looking at real contract relining example of an audit or inspection process and how to make it more supplier friendly without removing the purchaser's right. Let's read the audit clause first. In addition to any other rights of inspection, the purchaser may have under the statute or otherwise. The purchaser, its authorized representative, or an independent auditor identified by the purchaser may own expense during business hours and upon 24 hours notice to the supplier, enter upon the supplier premises at the purchaser's discretion, inspect and copy any records relating to the contract. Let's quickly understand what the original clause is. Sorry, I forgot to make the second part, which I should not have been doing. The supplier must permit the purchaser to exercise its right under the section. So now let's understand what the original clause allows. Purchaser could enter premises. Only 24 hours notice is required. Access to any records relating to the contract. No real restrictions on spoof or disruption. In simple terms, it's too wide and too risky for the supplier. So now let's refine this particular audit. Yes. The first thing that we are going to do here is the consent control. Audit is now subject to the prior written consent and not unreasonable withheld. This prevents arbitrary inspection. Second, extended notice period. Notice is increased from 24 hours to at least 3 business days. This allows proper preparation. Third is controlled access. Location is limited to the mutual consent or as determined by the parties. That is, it shall be at supplier's place or somewhere that is mutually agreed, which adds flexibility and control. Next, we are narrowing this instead of any records, now covers only the records that are directly related to the contract performance. This avoids overreaching fishing expeditions. So now this particular clause reads as addition to any other rights of inspection, the purchaser may have under the statute or otherwise the purchaser, its authorized representative, or an independent auditor, subject to the supplier's handwritten consent, not to be unreasonably withheld at its own expense during business hours and upon at least 3 days business. It is 3 business days notice to the supplier access to the supplier's relevant record at the supplier's premises or such other location as mutually agreed and copy those records directly related to the performance of this contract. So this is how we are going to rewrite the first paragraph. And we are going to entirely strike down the second paragraph and replace it with the supplier should reasonably cooperate with such inspection provided one, such inspection does not unreasonably disrupt the supplier's business operation. 2. All information accessed is treated as confidential. 3. No access is granted to third party confidential information or information not related to this contract. Now, let us break this particular paragraph. Let's start with cooperation. It is reasonable. The supplier agrees to cooperate, but no unreasonable disruption to business operation. It protects day to day function. All access to information must be kept confidential. Hence, this ensures data protection. No access to any kind of confidential information which is related to the third party and which is irrelevant to this particular contract. This prevents legal and contractual breaches. So this is how we are going to define the audit clause. If you found this helpful, don't forget to like, share, and subscribe to the channel. If you want more and more contract redlining tips, let me know in the comments. See you in the next video.